a hoarse voice. Talking too much, not yet. Anyway, then they set about and they produced the Australia Act in 1986. The Australia Act, they used section 51, subsection 38 of the Constitution. It said the states, the federal parliament has certain powers in certain areas. But they forgot to read the text that goes with it in the annotated Constitution, because it says this section imposes no more authority on the federal parliament other than what's contained in section 51 of this Constitution. Well, in section 51, subsection 21, I think it is, it states, subject to this Constitution, the federal parliament has the authority to pass laws for the good government and well-being of the Commonwealth of Australia. It has no other powers, and they are limited all in section 51 of the Constitution. The state gains their power under section 2, subsection 1 of the state constitution. But when the state government passes a law, most people don't know what the legislative system is in this state. When the lower house of the state parliament passes a law, it is an act. It isn't an actual authoritative law. It is simply just an act. It goes then to the upper house of parliament. If they approve it, it goes to the governor. The governor does not sign it straight away. He then sends it to the Chief Justice of the Supreme Court, which we don't have at present, but I won't go back into that. He must weigh it up against the Constitution. If it is found to be lawful under the Constitution, he must sign off on it. It then goes back to the governor, who stamps it. Now, if you look at the acts, it says, this act binds the Crown in relation to the attached matters. They still left that bit on, but they forgot the royal identifier, which has the Lion of Judah and the unicorn and the crown on top and all the shield and everything else. So, since 1973, there is no act passed in this state that is valid. That includes the Local Government Act of 1996, which is what they're using. No single act passed without a royal identifier is valid. You go through all the acts, you can go onto the government website, it's State Government Law Publishers, and go into all the acts and you'll find out it's not on any of them. It's all missing. So none of them are valid. But as I said before, the state constitution as put in place in 1900 was an invalid constitution, therefore no act ever passed in the state of Western Australia since 1900 is valid. So that'll get the attention of the court, and it does. You'll see them get upset. Now, some friends of mine and I have put in place some pretty serious stuff over the last few weeks. I'll tell you about that and I'll allow you to ask me some questions, because a lot of what I've got here is pretty deep stuff and you don't need too much at one time or you're not going to remember it. And I want you to remember, because I want you to go out from here and do something about it. People have to get the balls to stand up and say, enough is enough. You're not having our country, you're not having our property, you're not taking our Crown land. This is what I put before the Supreme Court, and that was on the 9th of August this year, 10th actually, and I've got to put my second set of eyes on to read it. This is a prerogative writ of mandamus. It's issued under section 75(5) of the Federal Constitution and is a right you have. Any person can issue this writ. As you can see, it's one sheet of paper. It's very, very simple. And it states, this writ commands you, this is to Wayne Stuart Martin, the so-called Chief Justice of the Supreme Court. This writ commands you to remove yourself from the Supreme Court of Western Australia for wrongly claiming to hold office under the Commonwealth, being Chief Justice of the Supreme Court of Western Australia, while not having sworn an oath of allegiance to Queen Elizabeth II, her heirs and successors according to the third schedule to the Federal Constitution. This has the effect of creating a pretend court, because that's what it is. Or show cause why you haven't done what has been described to you. You are required to make a return to this writ by filing a notice on or before the 30th of August 2010 stating whether you have done what you are commanded to do by this writ or stating why it has not been done. Take notice that disobeying this writ is contempt of court, which may be punished by imprisonment, fine or both. It's signed by a Justice of the Peace, and this writ under 75(5) of the Constitution being a prerogative writ, it's the Queen's prerogative. Your right to issue it is the fact that you're sovereign. So I'm just Joe Blow off the street, an ex-cop, and I build carburettors for cars and design fuel systems, but that part is irrelevant. The fact is, I'm just an everyday person, just like you. You can do these same writs. I don't advise you to do them at present because we've got two sitting in the High Court. We've done the preliminary paperwork, and the Chief Justice of the Supreme Court's got a lot of problems. He's going to jail for the rest of his life.
Good.
This Friday, this full writ will be entered in by Dr. Sir John Walsh, a barrister friend of ours. He's putting it in because the High Court won't throw it back out if he does it. The issue is, Wayne Martin has to step down from the Supreme Court. He has to then prove his sworn oath of allegiance to the Crown. On several occasions, I have conned him into admitting in the court that he's sworn an oath of allegiance to the state, without telling him why he's done it and not telling anybody else. Systematically over the last 12 months I've entrapped him. Big deal, get over it. He's a criminal. A worse criminal than anybody else because he knows better. The problem is, there isn't a magistrate sitting in the court in Western Australia that's sworn an oath of allegiance to the Crown. So we didn't want to leave them out. We wanted to make them part of the system. So the day on the 10th when I handed this up to Mr. Martin, as soon as he got it in his hand, I read it to him and he said, "You have to get this order from the court." I said, "Wake up to yourself. This isn't a writ under section 33(1)(d) of the Federal Judiciary Act. This is under 75(5) of the Constitution. It's a prerogative writ." He knew exactly what I said, and he turned around and he said, "But you haven't served it on him." I said, "Well, you're not very bright because it's sitting in your left hand. For the record, you have it in your hand, so it is served on you." I then walked out from behind the bar table, around behind the fence into the public area and said, "I'm leaving the court. You have it in your hand, it's served." And walked out. He couldn't deny it was served and it's all on tape. The next day I drove to Kalgoorlie and a friend of mine handed up another writ which we previously prepared on Felicity Zemplis, the magistrate in Kalgoorlie. The one, if you've looked on YouTube, that lovely lady that says, "This is not a common law court, it sits under my authority."
Yep.
Well, sorry, you're now sitting under ours and you go to the High Court and explain to them why you did what you did and said what you did. She was sitting there teary-eyed saying, "Well, what did I do to deserve this?" Well, I said, "Well, it's on YouTube, go and have a look. You're a movie star, but you've got a problem. You're going to jail for the rest of your life." Just sitting there shaking. She is a criminal.
Australian constitutional crisis.
Yes. The issue that I'm trying to instill in people's brains is, we're sovereign. Sovereignty means you are an individual person. You can do anything you like in this country as long as it doesn't affect somebody else. And you don't break any of the laws prepared for good government. We have to sift through the laws. I understand it is very hard for a lot of you to understand the laws. Some of the laws are so complex, I like to chuck them all in the bin and start again. You can't, unfortunately. Some of the laws are good, but the majority of them are total rubbish. All your so-called acts, your so-called regulations, and these intergovernment notes they put out stating that you've got to do so-and-so and, "Oh, we've got a ruling," that's all crap. It's total lies. The council passes bylaws. Well, I've got some news for you. All the laws passed in this country by the parliaments are bylaws to the Constitution. They are subject to and must comply with it. Chapter 1, subsection 5 of the Constitution is very clear. It says, "Not all laws of the Parliament are valid. The laws passed pursuant to, in accordance with, and under the authority granted by the Constitution, and those laws only are binding on the courts, the judges and the people." We're people. The court belongs to us. The judges are our servants. Why aren't they obeying them? Because we sat back and let them get away with it. She'll be right, mate. "Oh, we'll go down and have a barbie on the weekend. Who cares about the election?" Sorry, start caring. Sorry, wake up. You mightn't know, but on the 1st of July last year, it became law in this country that when you die, your body belongs to the government. So we played funny.